Yeah, no other question.
No other questions? You pass the witness?
Yes.
Okay, hang on just a second. I'm back with you. I apologize. One of the things on these Zoom hearings that we're required to do is hold them in open court and turn on a YouTube, and I sometimes forget to do that, and I was making sure it was up and running and not interfering with the sound on this one, and that's what I was doing while you were speaking there just a moment. But I did hear the testimony. Do you have no further questions for Mr. Walden at this point, Mr. Hanlon?
That's correct.
Thank you. Mr. Walden, did you wish to respond or ask yourself questions or testify in any way? And since he asked, you were called as a witness. Do you want to cross-examine yourself or whatever?
No, Your Honor. No, Your Honor. But if I could reserve questioning for Mr. Hanlon.
Thank you. Mr. Hanlon, anything else that you wish to present at this point?
Only some argument, Your Honor.
All right. Well, I'll let Mr. Walden do his argument first, and then I'll let you do your argument, and then we'll go back and forth on that for a few minutes, okay? So it's your motion. It's your motion, Mr. Walden. What is your closing argument?
Your Honor, before I close, if I may be allowed rebuttal for some brief questioning for Mr. Hanlon.
You may call Mr. Hanlon as a witness. Mr. Hanlon, I'll consider you under oath at this time as a witness. Is that all right with you?
Yes.
Thank you. All right, Mr. Walden, you may ask Mr. Hanlon a question.
Sir, with regard to the email that you just referenced in my testimony, did you respond to Ms. Nance with any documents?
I object to the question. I don't think that's relevant, Your Honor.
I'll overrule the relevance. There was questioning about this email, and the question is, did you respond to the email with any documents? I think that was the question. Is that right?
Yes, Your Honor.
All right. I think that's reasonably relevant. You may answer the question, Mr. Hanlon.
No, there was no indication that Mr. Walden was entering an appearance or representing Mr. Kendall. It just seemed like they were looking for just a courtesy response.
Thank you. Any other questions, Mr. Walden?
No, Your Honor. Pass it.
All right. Do you have any other witnesses you'd call? Or do you have any testimony you want to offer other than your answer to that question, Mr. Hanlon?
No.
Thank you. All right. Mr. Walden, any other witnesses you'd call?
Move it rest, Your Honor.
All right.
Your Honor, actually,
Yes. Go ahead.
I'm sorry. There was one thing I did want to make mention to the court by way of testimony, if you don't mind.
I do not mind. Go ahead.
Okay, Mr. Kendall testified that Desiree vacated the home at 710 Blue Stem Drive. That is absolutely not true. She suffered an overdose, was removed by an ambulance service, so she did not vacate the home. I just want to make that clear for the record. I don't know how important that is, but I just want to make that point. Thank you.
I understand. Any further cross on Mr. Hanlon?
No, Your Honor.
Thank you. Okay. No other witnesses then, Mr. Walden, and you rest at this point on your motion for new trial?
Rest, Your Honor.
All right. Mr. Hanlon, did you have anything else you wanted to present?
No, thank you.
All right, so you rest. Mr. Walden, closing argument.
Yes, Your Honor. In accordance with the testimony, Mr. Kendall had stated that he made a mistake. It was inadvertent. It was not an intentional mistake not to answer in the lawsuit that was filed by Mr. Hanlon for the partition of the marital property. A prior petition to do that very thing, not only with the real estate, but also with other items of personal property, was filed with the 440th District Court. Mr. Kendall testified that he relied on that fact and with the mistaken belief that his counsel would have been also provided a copy of the filing that Mr. Hanlon had filed. Mr. Kendall raised at least two defenses that he would have brought out in the hearing if he had appeared. One would be that there should be a disproportionate distribution upon the ultimate sale, if any, of the residence based on his payment of the mortgages, specifically adjusting for the principal to be paid back to him as opposed to the other party. He also would have raised the defense that the sale of the house could have possibly been delayed with the discretion of the court based on the fact that there was a child residing in the house. He could have at least raised the defense at trial that if the court was going to order the sale, that the sale be ordered at a later date to accommodate the child's needs. So both a defense, two defenses potentially, and testimony on inadvertence or mistake. Mr. Kendall is stating that he's asking for a new trial, which is consistent with Craddock in this case. Thank you.
Mr. Hanlon, do you want to make a closing statement?
Yes, please. So we have several things here that are important. First, under Rule 321 of Civil Procedure, it states each point relied upon in a motion for a new trial shall briefly refer to that part of the ruling of the court in such a way that the objection can be clearly identified and understood by the by the court. If we look at the motion for a new trial, all it says in paragraph 5 is Jesse Michael Kendall has a meritorious defense to the cause of action alleged in this case. That is not an objection that can be clearly identified and understood by the court because it's not specific. Meritorious defense, that could mean anything. So I don't believe that this motion for a new trial complies with the rule. Under Rule 322, it states grounds of objection couched in general terms shall not be considered by the court. So, and then under Rule 320, it says new trials may be granted and judgment set aside for good cause. And under Craddock, as you've mentioned, there's three criteria there. First, the failure to appear was not intentional or the result of conscious indifference. Well, I think we do have conscious indifference here. Mr. Kendall flat out ignored the pleading that was served on him. He did not give it a copy to his counsel. He did not mention it to his counsel. That's just pure neglect there in a major way. Point number 2 under Craddock is there's a meritorious defense. Well, there, as I said, citing the rules of the civil procedure, no meritorious defense was outlined there. Just, I have a meritorious defense. Well, what is it? There's no explanation of it. And then number 3, granting a new trial will not operate to cause delay or injury to the plaintiff. This will absolutely cause delay. The court will have to schedule a new date for trial. They're asking to delay the sale of this property. As I've explained before to this court, Desiree Kendall is trying to get insured in the state of Arizona for health insurance, and she can't as long as this property is not up for sale or sold. So it's going to cause prejudice to her. This property was ordered for sale by the receiver back in April. We're now a month past that, and the property's still not sold, and Desiree can't qualify for insurance if the court takes this property off the market. So it is going to be prejudicial to her. This could have been easily resolved by Mr. Kendall contacting his attorney, giving him a copy of the pleadings. His attorney and he could have then appeared at the trial. And it's very clear from this email that Mr. Walden has acknowledged that as early as March 12th, a whole month before the hearing in the partition case, that his office was aware of this case. And they cannot rely on me as a courtesy to provide them with documents that are readily available at the court or through Mr. Kendall. So they had an obligation to do their due diligence and follow up on this. And now to come into the court and say at the last minute, well, now that it's about to be sold, please stop the whole thing because we were neglectful, both Mr. Kendall and Mr. Walden. So I don't see good cause here for a new trial. These are tenants in common, as I understand it, and are entitled to equal disposition of the proceeds of the sale. I might have a moment here. So I guess the most important point is that this will injure Desiree in her ability to get health insurance in Arizona and to get her share of the proceeds of the sale so she can pay her medical bills, which are at this point quite substantial. She's been in a nursing home for well more than a year now, and it's not fair to the healthcare providers that they're not getting paid when there's resources that can be used to pay them. And they have actually threatened to discharge my daughter from the nursing home.
Facts not in evidence.
If they don't get paid here. So it is going to cause irreparable harm to my daughter if we can't proceed here. Perhaps for
Objection, facts not in
have a
evidence.
new trial.
Sustained as to your objection. Anything else, Mr. Hanlon?
Not at this time.
Thank you. Okay, I've listened to your closing arguments from each side. And I understand each side has their own perspective on this. As I stated earlier, the credit tests that are involved require some excuse, but not necessarily a good excuse, which that's still the case in Texas. As the Supreme Court has said, the law abhors a default. As trial judge, whenever a default's taken, the court always has great concerns. I indicated at the time that the default was taken in this, that if Mr. Kendall appeared in the case, we might have additional hearings in regard to it. Here's the issues that I've got in this case, gentlemen. The court has put in a significant amount of time on this case, and that's fine. Courts are supposed to put in time. The court has also found a receiver, has directed the receiver to proceed with the sale of the property. That receiver may have incurred undoubtedly has incurred additional effort, and receivers should not and are not required to work for free. In this particular case, the court was going to wait until a sale took place and pay the receiver out of the proceeds, because Mr. Hanlon's client has no cash assets. This property is listed as an asset of hers, and it creates some problems. There's been testimony in our original hearing as to the value of this property by an appraisal. The receiver indicates that appraisal is probably out of date and inappropriate. And frankly, I think that based on the condition of the property at this time, it's not going to draw as much. I have additional concerns, and these are only concerns. I don't have evidence yet at this point that when it gets to a sale on this property on a partition, that there may not be a great deal of equity to divide up anymore. Even that would still provide additional relief to Miss Anderson, who's incapacitated and not receiving benefits because she's a joint owner in this property. So just the removal of that joint ownership would be additional relief to her. But that's not what the Craddock test, I think, contemplates. Mr. Walden, your client's going to have to be able to compensate the receiver for their efforts up to this point if this court shuts this case down.
Your Honor.
And that's something that you need to contemplate and deal with. But I am concerned that there is a pending case that would divide not the marital estate, but would divide the estate of the annulled marriage. And had that been the case here, this court would have said, had I been aware that that there was a pending case, this court would have said, I can't proceed until those issues are resolved. So that's an issue that needs to be taken up. And I would have taken that up. Mr. Hanlon, just a second, I will let you talk to me in a second. But I want to get out everything I want to say right now so you can respond to all of it, okay? But that's the position the court's in. Both sides need to get all of this straightened out, and that's a terrible situation to have happen here. Okay, Mr. Hanlon, what did you want to say?
It seems, based on arguments that Mr. Walden has made about the disproportionate distribution, that one way or another, this property is going to get sold. And it seems to me that maybe the better course would be to proceed with the sale. The proceeds can be deposited in the registry of the court less the receiver's cost. And then if there is anything left, we could have, if the court is inclined to grant a new trial, then do the new trial after the sale. That way, Ms. Kendall is not burdened by continuing ownership in this property, preventing her from getting her medical benefits.
I understand. I understand your argument there. And here's where I'm at right now. Okay, I don't have evidence as to what this property is actually going to sell for. I have rumor and innuendo that I've gotten back, okay? And I think you may have heard those things also, Mr. Hanlon, and speaking directly to the receiver. Is that correct? You've talked to the receiver directly?
I have, Your Honor, and I've also asked him to provide me with pictures of the inside of the property because I may make an offer on this property, and he has.
That's fine. I understand. And you know, I don't care. I mean, you know, Mr. Walden, you may want to get pictures of the interior of the property and that sort of thing. That's going to affect the sale price on this property. And I'm just talking out loud here, guys. And one of the things I'm really afraid of in the partition is that we're going to get to a sale. There's a current indebtedness on this property to Navy or somebody. I can't remember what. Okay. I've got another case that Navy Federal Credit Union's in too. And so I didn't want to get them mixed up. But anyway, there's an indebtedness there. It's in the range of 80,000.
That's correct.
Okay. Is it the low end of 80 or the high end of 80?
The low end, it's about 81,000.
Okay. If this property sold at $100,000, then you're looking at approximately $20,000 differences there. That there's going to be expenses of the sale. You know, if it was sold by a regular real estate agent, it would be 6%. And that would knock, you know, $6,000 out if it was $100,000 sale. And that's about the most the receiver thinks it could come in at, probably below that. The receiver is going to get more than 6%, probably closer to 10% awarded on the sale. That knocks out half of the equity if it sells it at 100,000. That knocks the parties down to about $5,000 per side. And I'm just thinking out loud. I have no idea what will happen, but that's what you're looking at if this were sold at 100,000. It puts Mr. Kendall and Samantha in a situation of having to go and rent property somewhere else, maybe enough money to make a down payment. But it's been clearly pointed out in the pleadings, whether it's true or not, that Mr. Kendall probably has some credit issues, and it makes it hard to rent somewhere when you go to rent because any landlord checks credit histories. That creates issues. Both sides are going to have issues. The court would have that in the registry of the court. In addition to that, I've got another case pending between these same parties in which I have ad litem and ad litem fees that are mounting in that case because of that. And I could easily take a portion of the funds from both sides and transfer those into the registry of the court in that case to cover anticipated fees. And the court has the authority to do that. So it'd end up where nobody has anything. And I don't know that that solves any problems other than the problem that Mr. Hanlon's facing, where he needs to get benefits for his daughter that's in the nursing home. And I don't know the solution to all these issues, gentlemen, but they're troubling. They're very, very troubling, and they're troubling to me as a judge. And so I've got to go back and just rely on the rules and the law as it's set out and make my rulings based on the law and the evidence that's before me. Some of the stuff I've been talking to you about in the last couple of minutes, y'all both know is not in front of me as evidence at this point. At some point, I think it would be when the receiver comes back and tells me what this property will sell for. And I have no doubt that that receiver would indicate to me that it'll sell for less. Mr. Hanlon filed a motion in this case to have an additional appraisal. The appraiser, frankly, told me that he had not requested that, but if Mr. Hanlon wants him to do an additional appraisal, he'll do it. That's outside the evidence in this case, but that appraiser came back in and said he didn't think it would benefit anyone for him to go out there and go through the property other than run up additional expenses. Mr. Hanlon didn't pursue the motion to have additional appraisal, so it's just basically laid there, and that's fine. But I don't doubt that the proposed division of this estate, that this property that these two people own, is not going to bring in a pile of money. I wish it would. I wish it was in prime condition and would sell for 130-something thousand, and both sides would have some assets and that sort of thing, and be able to move on, make a down payment on a house, and all those wonderful things. But this is a very sad and difficult case to find a happy resolution for both sides. Most divorces end up that way. This is even more complicated because it turned out not to be a divorce through nobody's intent. It turned out to be a void marriage. So anyway, going back to all that said, going back to the issue in front of us today, the motion for new trial. If I deny the motion for new trial, Mr. Hanlon, I'm confident that the appellate court would reverse me on that. I understand the law you've quoted to me, the objection to the petition not being more clear, or the motion for new trial on element 5. The law wouldn't require that the meritorious defense be set in detail in the motion. The law simply requires that there be a statement that there is a meritorious defense. If that statement wasn't there, then, and I understand you read the rule differently, but I don't think the appellate court would read it the way you do. And I don't think this court does. Likewise, were I to deny the motion for new trial, this would further delay everything in this case and make it get even deeper. The court's going to have to go ahead and grant the motion for new trial in this particular case. Then the question is, with this pending motion for dissolution or to declare the marriage void, if the court would then just simply stay the proceedings in this case until that issue is resolved in that case. I've already got a ruling out of this court that that marriage is void, and no evidence was presented during that case. So then the question comes up as to whether the new one, which was filed prior to this, the issues that are complicated in that. And I'm not assigned on those two cases at this point, so I don't have to worry about them. I'll let Judge Kinsey sort that out as to whether he proceeds on that, whether he thinks that the order that was entered in the divorce proceeding cancels his case out or not. And that's going to be an issue he has to address. And that sort of thing. But at this point in time, the motion for new trial on partition is granted, but I'm not happy about having to grant it, but the law says I must. At this point, and I'll notify the receiver to stay the proceedings on the sale. And the court will notify y'all of a date that the new trial is being set for. I'll have to look at the calendar and figure out what's going on. And then I assume at that time you'll have to determine whether or not you can attend that motion or not, or that new trial. But that's where we're at, gentlemen. I'll sign an order a little later today on this. if you'll submit a proposed order, Mr. Walden, I'll review it, and if I don't like it, I'll make my own. Mr. Hamlin, I'm not happy about having to do this. I just don't think the law gives me any choice in this. This matter needs to be settled and resolved for everybody. It's too painful for all sides. Thank you very much. That's the end of this hearing.
Your Honor,
Yes.
you had previously directed the court coordinator to send me a copy of the order in the divorce case.
Still haven't gotten it?
No, she sent me another order. It's not the one in the divorce
I'll
case.
send it to you. I'll send it personally, just directly to you.
Thank you.
Okay. Thank you. And I'll copy you on it, Mr. Walden, so that I'm sending it to both sides. Okay. And I'll try and do that sometime today, if not today, by Monday. Thank you very much.
Your Honor.
Jeannie, we're done for the day. Thank you so much.